It's important to remember, I think, to start with, that competition damages litigation in the UK is only about a generation and a half old. And the collective actions part of that is, as you said in your introduction, only about 10 years old. And one thing that's particularly interesting about that is you'd have thought that in a period of 10 years, you would have had a very, very substantial amount of movement and progress. And that certainly seems to have been the position that the government has taken recently. But in actual fact, if you look at the first 5 years of that regime, very little happened. And that's because one of the first cases to be filed, Walter Merrick's against MasterCard, certification was initially refused and was not finally granted until about 4 or 5 years after the case had originally been filed. So for half of the period that it has been in place, we have had very, very little movement. Since then, there has been an explosion of cases. A large number of mainly opt-out, mainly standalone cases have been filed in the UK. Some of these cases have now settled. And we have had recently, in the last month, a full judgment finding both liability and awarding damages in the Kent and Apple case.